I start, madam?
Yes, sir.
Good evening, everybody. Vivekananda College of Law, jointly with Alumni Association, with the initiative of IQAC, have arranged first series. And today is the 11th day of first webinar series. And the today's speaker is R Anil Kumar, who is one of the active initiator and one of our alumni associates for the first webinar series today.
Thank you, sir. Thank you.
And Mr. Anil Kumar, Law and Practice. I also welcome, thank you. And I also welcome the principal of Vivekananda College, Sri Kempegoda sir, for the first webinar series of 11th day. Well, I welcome you, sir.
Thank you, Anil. Thank you, Girish. Thank you very much.
And also I welcome all the faculty members of Vivekananda College, the students of Vivekananda College and Alumnus of Vivekananda College, and also the office bearers of the Advocate Association who have participated here. And also I heartily welcome everybody who is going to participate today in the webinar series. Now I request Kempegoda sir, the principal of Vivekananda College, to give introduction about the today's speaker, Mr. R Anil Kumar sir. Over to you, sir.
Thank you, Girish. Friends, as Girish rightly pointed out, Janata Education Society's Vivekananda College of Law, in coordination with our Alumni Association, as an IQAC initiative, we have organized this program of webinar series, for which I congratulate all office bearers of our Alumni Association and all the members of our Alumni Association. Today we have amidst us Shri R Anil Kumar, who is also an alumnus of our institution and a core committee member of this organizing committee of webinar series. I take pleasure to give his brief profile to you all. Shri Anil Kumar is graduated from our own institution in the year 2008. He was adjudged as the best outgoing student of our institution in his batch. And he has attended 12 national moot courts competitions and 12 international moot court competitions. Still, one of his best performance is he won a Best Mooter Award, and also he won Best Memorial Award in the National Moot Court organized by KLE Society's Law College in 2007. Right from the beginning, from his first year, he was an active member of our Moot Society, where he worked with Srimati Saraswati, Vidyulata, Rakshit, and most of our mooters, and trained under them. At last, he won laurels he brought laurels to the institution through winning one of the national level competitions. He was enrolled as an advocate in 2008 and started his career in one of the Bangalore's oldest law firm, KSV and Company. He started his independent practice in 2016, specialized in election laws, property laws, contractual laws, arbitration laws, and practicing on civil litigation side, serving as an advocate for Advocates Association of Bangalore, which is having the distinction of Asia's largest advocate association. Shri Anil Kumar, I am really happy to have you on this occasion to speak on the topic ADR, and on behalf of Janata Education Society's Vivekananda College of Law and our Alumni Association and all the people, those who have gathered here to hear you on this occasion, I take pleasure to welcome you, Anil.
Thank you, sir. Thank you so much.
We have amidst us office bearers of Janata Education Society, members of Managing Committee of Janata Education Society, and our Governing Council members. I take pleasure to welcome all of them. We have the representatives from the Advocate Association Bangalore, particularly Treasurer Shri Shivamurthy sir. Sir, I take pleasure to welcome you on this occasion, and I welcome all the academics, those who are present here, and the faculty and students from other institutions, and the faculty and students of my own institution to this lecture series. And I welcome one and all. Thank you. Thank you, one and all.
Thank you very much, sir. Now, I request R Anil Kumar to start the webinar, sir. Over to you, sir, Anil Kumar.
Before starting, I request all the participants to fill up the feedback form provided during the webinar series. Thank you. Thank you. Over to you, Anil, sir.
Thank you, sir. Thank you so much. Today's topic assigned to me is regarding arbitration, the arbitration law and practice. So now if I have to begin with this topic of arbitration, a brief history if I have to take. Well, the arbitration laws, if we hear about the arbitration laws, probably we would feel that the arbitration law is something very new to our system, or the enactment is new, various statutory amendments are coming. So we feel that the Arbitration Act is something new to our system. But I intend to state that this arbitral system or the arbitral proceeding is akin to our society and is in existence from time immemorial. Even today, or even if we take our history, where during this Gram Sabhas or our village side, village heads sit together and they decide the disputes. This is possible, even today it's possible in occasions, on various occasions. So whenever we take about the case laws or the citations or our judicial laws, the Supreme Court judgments, it is based on the English laws. But what we could see is that before, even prior to these English laws codification came, we all subjected ourselves to these Gram Sabhas, where the Gram Sabha leaders were there, and they were deciding the disputes. All the ingredients which is there in the present enactment, we can see that in the earlier days, such as in section 10, presently we have got this arbitral tribunal, the number of arbitrators who should be constituted. This was existing in the earlier period also, where the heads of the Gram Sabhas used to said. There is no appeal clause in the arbitration enactment today. Likewise, the same, whenever the adjudication was made earlier, it was considered to be final, and people used to act on that. And also hearing of the parties, everything. See, the basis for the present arbitration system is that there should be quick disposal of the matter and least intervention of the courts. This was happening in our earlier times as well. So with this background, I state that the matter or the arbitration proceedings, arbitral proceedings is not new to our system. Then we got this Arbitration Act in the year 1940. Subsequently, the entire Arbitration Act was changed in the year 1996. And pursuant to 1996, in the year 2015, there was an amendment. 2019, there was an amendment. Again, 2021, there is an amendment. So we have got various amendments. If we start with the introduction of this Arbitration Act, section 2 talks about this definition clause. In the definition clause, arbitration agreement, there is a definition of arbitration agreement which refers to section 7 of the Arbitration Act. Now, if you go to section 7 of the Arbitration Act, there the arbitration agreement is broadly interpreted, stating that every clause or every contract having the arbitration clause is an arbitration agreement, and the arbitration agreement should be in writing. Now, what is this writing? It is again explained in the very same clause, stating that even these telecommunications, telex messages, these are all considered to be as writing, in the form of writing. Now also, It recently added that even in this electronic form, if it is there, that is also considered as writing. So this is the broader definition of arbitration agreement. So when such being the case, the questions would be that, so if there is an arbitration clause in the agreement, then all the matters or all the disputes, whichever contains this arbitration agreement, it should be referred to the arbitral tribunal. But this is not so, which is happening now because of the judicial interventions. See, under arbitration agreement or arbitration enactment, there is no restrictions of any statutory restrictions is provided stating that these disputes can't be arbitrated or these disputes can't be referred to an arbitral tribunal. This connotation is not there in the statute. However, the judicial interventions, we can see many restrictions, exceptions being provided. So if I have to begin with that, for instance, if I take dispute relating to fraud. So if a dispute is relating to fraud, at the earliest time, I think the first case law which I could find was in the year 1961, Abdul Qadir's case, where the matter relating to fraud, the court said that whenever the dispute relates to fraud is of a limited extent, where it does not go into the touching the arbitration contract itself, then such a matter of dispute relating to fraud can be referred to arbitrator. However, this while passing this judgment, there was a reference to one earlier judgment of Chancery Division, England, 1890 decision, Russell versus Russell. The very same principle laid down in that case was followed in this 1961 judgment. Thereafter, what happened in the in Radhakrishna's case, this dispute relating to fraud was again narrowed down, and court said that, see, when there is a lot of evidence should be looked into, a lot of documents and papers, investigation should be carried out, such matters you can't refer it to arbitration tribunal or the arbitrator. It's the court alone which has to look into the issue. And then what the court did not refer the matter to arbitral tribunal, and it rejected the application which was filed in that particular case. So once in Abdul Qadir's case, when the broad definition of when fraud was given a wider connotation and referred to arbitral tribunal, it was narrowed down in Radhakrishna's case. Subsequently, also thereafter came this Booz Allen's case, Booz Allen Hamilton versus it's State Bank of India, I think. In the year 2011, this case was there. This is one of the leading cases. See, we can see various cases where the laws have been subsequently laid down, or those cases have been held bad because of statutory amendments. However, this particular case, Booz Allen's case, is a very important case because this was the case where it dealt with two propositions. One is that which are the cases which can be arbitrated or which can be referred to arbitral tribunal, and which are the cases which can't be referred to arbitral tribunal, and what the court should look into at the time of referring the matter to arbitral tribunal. Now, before going into this Booz Allen's case, I would bring about the provisions of the section 8 and section 11, because in this context, section 8 and section 11 will be important for the reason that section 8 and section 11 are the two provisions where a reference is made to arbitral tribunal under the enactment. One is section 8, other one is section 11. Section 8, what it states is, if a judicial authority, a matter is pending before a judicial authority, a party in his first written submission, in his first submissions, he should make aware to the court or acquaint to the court that there is an arbitration clause and he should seek reference to the arbitral tribunal. However, in section 11, it is not the party who will be filing, it is not at the stage of the judicial authority, but whenever the dispute arises, one party should issue notice, and then if the other party does not agree for arbitration tribunal or the arbitrator suggested by that party, then the matter will be, or an application should be filed before the High Court, before the Chief Justice or his designate court in the matters of arbitration. If it is international commercial arbitration, then it is Supreme Court. The honorable judges, the honorable court would refer the matter to arbitration. So this is in a very broader way, I'm explaining section 8 and section 9. To be little specific, in section 8 is in such a way that, for instance, a partnership deed is there. If person would have filed a case for partnership, dissolution of partnership form, or any dispute regarding to partnership, notice is issued to other side appears before the court, and he states to the court that filing this application that see section 8, I'm invoking section 8 provision for the reason that there is an arbitration clause in this, and refer the matter to arbitral tribunal. This is a place where the court will start seeing now whether the matter can be arbitrated or there is an arbitration agreement. Can it be arbitrated and referred to the arbitral tribunal? This is under section 8. Section 11 is that where there won't be any case at the initial stage. If there is an arbitral clause in this partnership deed, one partner will issue to the other partner stating that, see, there is a dispute amongst ourselves. I'll file a case now. I want to file a case, resolve it through an arbitrator. So I'll be filing a case. This is the arbitrator which I'm suggesting. If the other party agrees, within a period of 30 days, he should reply to it. Otherwise, then this party who had issued the notice, he can file a petition before the High Court or the Supreme Court if it is international commercial arbitrations. Then the court will look into the matter, what is arbitrable or not, and the matter will be referred to arbitral. In this context of section 8 and 9, I'll be taking you through this Booz-Allen's case. See, now I said in the section 8 and section 11, the matters which can be arbitrated should be looked into by the court. Now, which court should be looked into is the question. Because under section 16, there is a provision which says that the arbitral tribunal itself has got jurisdiction, or it has got its competency to look into its own jurisdiction. This is based on the doctrine of competency, which means if you refer the matter to the arbitral tribunal, the arbitral tribunal would say that I will look into it, whether it can be arbitrated or not. You adjudicate it to me. This is the statute which has been provided, a special provision which has been enacted in order with the basis that minimum judicial intervention should be there. Now, in this Booz-Allen's case, what were the contexts the court said? The court said that, see, all the matters can't be referred to arbitral tribunal because there are many restrictions which are there. What are these restrictions? If a matter is pertaining to a jus in rem, where a right against the whole world is asked, such a matters, it can't be dealt by the arbitral tribunal. It can be dealt only by public forum. This is one of the aspects which has been raised in Booz-Allen's case, one of the facet which has been provided in Booz-Allen's case. And also the Booz-Allen's case, it says that only if it is in right in personam or a right arising out of, a subordinate right arising out of right in rem, in such cases alone, the matter can be referred to arbitration tribunal. So these are a lot of judicial terms which I've used, right in rem, right in personam. Let me explain with an example what it is. See, if a contract is there between parties, take for instance, landlord and tenant contract. In landlord and tenant contract, the landlord and tenancy law which governs in general is Transfer of Property Act. For instance, if a landlord wants to evict a tenant, he will invoke the provisions of Transfer of Property Act and will issue a notice, and a suit will be filed. Now, there is also a specific provisions enacted in particular states, especially in Karnataka. There is also in Bombay, in Delhi Rent Act is there. Karnataka also Rent Act is there, where these small tenants are protected, where the area of the land or the scheduled property is small, the rent is very less. In such cases, these tenants are protected under these special enactments. In such cases, what the Booz-Allen's case court says is that whenever statutory right is given or a person is protected under a statutory right, in such cases, the matter can't be referred to arbitral tribunal. So this was what stated in the Booz-Allen's case. In general, it was connoted. Now, then the very same case also gave out certain other restrictions, such as in matrimonial disputes, in disputes regarding to criminal laws, in dispute regarding to patent laws, wherever sovereignty is involved. In such cases, in all these cases, the matter can't be referred to arbitral tribunal because it involves jus in rem. In such a situations, the matter can't be referred to arbitral tribunal, is what the decisions taken by the court. See, before this happening of 2011 case, there was one more case called as SPP versus Patel's. I don't remember. In 2005, SPP versus Patel's engineering case. In that particular case, it was a 7-judge constitution bench, which was constituted to find out what matters can be sent to the arbitral tribunal. The court gave out a huge list which stated that under section 8 and section 11 itself, the court can look into all these disputes such as whether the matter can be arbitrated, whether the courts have jurisdiction to look into the matter, whether the matter can be referred to arbitral tribunal, whether limitation, even the question of limitation also was dealt by the court itself, court under section 8 and section 11, that is the reference court. So all these matters can be dealt by under section 8 and 11 was the constitutional judgment. This judgment was legislatively overruled in the year 2015 by way of amendment to the 2015 Arbitration Act. So thereby, limiting the court's functioning at the stage of reference, that is under section 8 and section 11. Now, when it limited this context of section 8 and section 11, the court started looking into only few aspects. These aspects were whether prima facie the document can be looked into and find out whether this matter can be referred to an arbitration or not. See, this arbitration, as I said, it's always an evolution of law. At least in India, in this country, this is an evolution of law where the matters or through these judicial interventions, the law is evolving every day in and day out. For instance, when I refer to this dispute of fraud or this tenancy agreement, landlord and tenancy, the initial stages in the year 1981, the first case, it was in that particular case in the year 1981, insofar as the landlord or tenancy is concerned, the court held that it was relating to Bombay Rent Act. The court held that when there is a special provision involved, the matter can't be referred to arbitral tribunal and the civil courts alone have got jurisdiction. Subsequently, even in Boozalan's case, though the matter was not related to landlord and tenancy, this aspect was dealt with and brought out this enshrined with this concept of jus in rem and jus in persona. Subsequently, what happened? Various judgments of our high courts, maybe the Delhi High Court, Andhra Pradesh High Court, they gave against ruling stating that even under Transfer of Property Act, the matter can't be referred to arbitration tribunal. Then in 2017, Himangni Enterprises, in this particular matter, Himangni Enterprises, in 2017, the Honorable Supreme Court specifically said that matters relating to arbitral tenancy landlord dispute, it can't be referred, even if it comes under Transfer of Property Act, it can't be referred to arbitral tribunal. It did not overrule Boozalan's case. It took the clue out of Boozalan's case and interpreted the law in a different manner, stating that transfer of property is also a special enactment. So therefore, the matter can't be referred to arbitral tribunal and can't look into the matter. Thereafter, in Vidyadhar's case, Vidyadhar's case, this was in the year 2021. All these aspects were taken into consideration. This is one of the landmark judgment which you can make note of or go through this judgment, where every matter, every aspect of the matter, what can be arbitrated, what can't be arbitrated, and all our earlier decisions were taken into consideration. And this enactment, judgment was passed in such a way that, holding that it gave out 3-tier tests. It held that these matters relating to landlord and tenancy, even if it is coming under Transfer of Property Act, it can be referred to arbitral tribunal. However, the only exception is that if there is any public statute, wherever exceptions is given. It interpreted Boozalan's case in a different manner, in a manner such that in Boozalan's case, it was clearly stated that if any statutory bar is there, then alone the matter can't be referred to arbitral tribunal. So therefore, court said that there is no specific provision in this Transfer of Property Act. There is no specific provision. It's a general law. So the court said that whatever the law stated in Boozalan's case and said, you can refer the matter to arbitral tribunal. But it, as I said, the evolution of law, it might again change as well, because for the reason that now we can see very recently, 15 days ago, Model Tenancy Act has been sent by the central government to all the states, so that asking the states to implement this enactment. Under this Model Tenancy Act, if this enactment comes, then again, the landlord-tenant disputes, a special provision is provided where jurisdiction of civil court is ousted and the jurisdictions of a competent authority is constituted, then a tribunal is constituted for appeal. So then at that juncture again, this landlord-tenancy, the disputes won't be able to be referred to arbitral tribunal. It will be the particular tribunal or the competent authority as the enactment has enshrined. So therefore, this evolution of law, what I said, keeps changing and interpretation will be there always. See, when I was talking with this section 8 and 11, I also made a reference to this section 16. Section 16, it is constituted on the principle of doctrine of competence, I said, which means that an arbitration, a doctrine of competence means an arbitral tribunal has got the jurisdiction, has got the powers to look into its own jurisdiction, is what the law of section 16 says. In fact, to give an instance, so far as Limitation Act is concerned, or say for instance, an arbitral award cannot be referred to an arbitral tribunal for the reason that there is barred under limitation. This happened. So this is a reported judgment of 2021, where an application was filed. Sorry, a notice was issued in the year 2007 for appointment of arbitrator. After 3 years, a reply was sent. But the court said that the limitation for passing or filing a CMP petition under section 11 for appointment of arbitrator is 3 years from the date of issuance of 30 days from the date of issuance of notice. Here in this matter, that limitation had crossed. Now the question before the court is, this limitation being a factual aspect, let it be referred to arbitral tribunal and arbitral tribunal decided. But what the court said was, see, if it is prima facie, if it is found, Limitation Act is both a procedural law as well as question of fact. If a question of fact which is already determined and available on record, for the sake of sending it to the arbitral tribunal, we should not send it. And prima facie we can see and find it out, the limitation is barred. In such an event, the court can itself say that limitation is barred. But in yet another case, where the disputed question of fact was there for the purpose of limitation, the court invoked this provision of section 16 and said, the matter has arbitrable in nature, and hence, the arbitral tribunal has got jurisdiction, which requires to go into the factual aspect and refer the matter to arbitral tribunal. So therefore, the law of the land presently today is that, insofar as the disputes which are arbitrable are concerned, the court should look into a very minimal aspect. This is for the reason there was an amendment in the year 2015, which brought down or narrowed down the jurisdiction of the court under reference, that is under section 8 and section 11. The court said that the general principle of law, what the court stated was, it was laid down again in this Vidya Dolia's case. The court said, if you have to look into the document and find out whether it is arbitrable or not, the only question is whether it is prima facie available or not. If you have to go deeper into the matter and find out whether it's arbitrable or not, then refer the matter to arbitral tribunal. Because court's main basis is that minimum interference is required. This is the concept of invoking Arbitration Act. Then later on we will see. Later on we will see in the sense, arbitral tribunal will pass an order. You can raise the issue in the arbitral tribunal. If you fail thereafter in section 34, again, you can come and challenge it. So at the initial, that is pre-reference stage itself, don't start interfering into the matter and make it as simple as it, refer the matter to arbitral tribunal. See, there are various, again, implications on this. Take, for instance, in section 9 and 11, again, there is one, see this section 9, before I moving further to the next case, I'll also bring section 9 into the context, because section 9, it is like wherever in our civil court, we file these temporary injunction applications. These temporary injunction applications, whenever you file in a civil suit, you bring it under our 39 Rule 192. This is almost similar to that, but however, very much distinctive for the reason of this is not a temporary injunction which is being given. It is an interim measure where you can invoke an interim measure before filing or application for invoking the provisions of arbitral tribunal. When under the arbitral tribunal, whenever you apply or issue a notice for appointment of an arbitrator, 30 days time is given for other side to reply for it. If that person does not reply within the time of 30 days, then you will be invoking provisions of section 11 and file a arbitral proceedings, petition for appointment of arbitration. Then this period you will be having at least 2 to 3 months it will take. So if there is an urgency in the matter, you want your protection, such as property protection or security protection, something you have to be protected, then you invoke these provisions of section 9 interim measure. Once an interim measure, see earlier what used to happen, whenever the court granted an interim order, they used to take this interim order and keep quiet. Thereafterwards, an amendment was brought to this, stating that if you obtain an interim order within a period of 30 days, within a period of 90 days, you have to initiate, you have to commence the proceedings. The wordings uses commencement of proceedings. See, again, the question starts is, what is commencement of proceedings? Commencement of proceedings is under section 21 of the Arbitration Act. Whenever you issue a notice, that itself is commencement of proceedings. So now also what people do, they obtain an interim order, they issue notice and keep quiet. There are these instances happening. Now, I bring to, in this context, there's one case law. See, this is pertaining to this with the topic. I think it will be relevant because law and practice is a topic where in this practice we follow this. We find this difficulty. Whenever a document we get it from our clients. Say, for instance, maybe a tenancy agreement or a joint development agreement. The agreement will not be registered, though registration is required, or the agreement will be unduly stamped, though stamp duty should be paid sufficiently. Insufficient stamp duty will be there. But there will be an arbitration clause. Now, how to deal with this? There was a matter in the year 2012, or 11 or 12, SMST estates case. This is a very famous case in so far as relating to dispute of unregistered document and unduly stamped document. The Honorable Supreme Court, it went on to the matter. There it was with reference to Section 11 alone, not Section 9, where a party would have filed an application. The document ought to have been registered because I think it was a tenancy agreement, landlord-tenant agreement for a period of 5 years. Document was mandatorily required to be registered, and it was also unduly stamped. In such an instance, the court said that it can't be referred to arbitral tribunal for the reason that two aspects were there. One is unregistered document, other one is stamp duty insufficiently paid. Court said for a collateral purpose, you can remove this restriction of unregistered document, stating that for collateral usage, you can make use of the document. However, for the usage of this unduly or insufficient stamp duty, it can't be referred. It becomes an invalid agreement, and the court did not refer the matter to arbitral tribunal. This matter was again came into consideration in Garware Holdings case by Bombay High Court. It was a 3-judge full bench decision, where the court said, court was referring to, see, earlier SMST's case, it was only Section 11, that is appointment of arbitrator. But here in this Garware's case, it was appointment of arbitrator and also under Section 9. Both the concepts were taken into consideration. Section 9 is where you're invoking interim measures. So the document was insufficiently stamped and unduly was insufficiently stamped. So both Section 9 and 11 was taken into consideration. Court said that if it is insufficiently stamped, then also you can give an order, pass an order under Section 9, and also appoint an arbitrator under Section 11. Now, the reasoning given by the Bombay High Court was that, see, there will be urgency in the matter. You would have invoked the provisions of urgency under interim measure. If you ask, if the court asks to withhold the document and say that go pay the stamp duty and come, then the provision itself will become ineffective. So that was not the intent for giving out the provision, passing the provision. This matter was again, I think in 2 months itself, this matter was came up before the Supreme Court. Supreme Court had the opportunity to consider this matter. So there the author was, I think, Justice Rohinton Nariman. So he passes an order stating that this was not the intention behind the SMST estates case. So you cannot, court has passed an erroneous order when law says that when under Section 9 or Section 11, no, it doesn't talk about Section 9. Supreme Court doesn't talk about Section 9. It talks only about Section 11 and says document should be stamped properly. Then only the matter can be taken into consideration and referred to arbitration. Otherwise, it will be treated as invalid document. See, in Bombay High Court, it had referred both Section 9 and 11. But Supreme Court here only took into consideration Section 11. Though it had taken into consideration Section 9, it did not answer anything in Section 9. So thereafter also, courts what used to do here, Section 9, whenever a document is unduly stamped, court used to give an injunction orders, stating that this is an exception. This has not been covered by Bombay High Court decision or Supreme Court decision in Garware's case. So people used to take advantage of this. In what way? They used to obtain an interim order. Then they would issue a notice stating that we will be appointing this person as an arbitrator. That is enough for initiation of commercial commencement of proceedings. They won't file an application under CMP. Now the other party who is aggrieved, he will file an application under Section 11 for appointment of arbitrator. Then he was the person who was supposed to pay stamp duty on the agreement. So this was the glitch which was happening there. Then what happened now? Very recently, maybe 2-3 months before, before this, this matter was again concerned Vidya Drolia's case. As I said, Vidya Drolia is a benchmark judgment. It considered every case. Each and every case it considered and passed an order what can be referred, what can't be referred. And approval was given to this Garware's case, in Vidya Drolia's case. Garware's case was a 2-bench decision. Vidya Drolia was a 3-judge bench. Thereafter was in another 3-judge bench in the matter of NN ropes, I think. In that case, the for the three-judge bench, what it said, section 9 and section 11, both it interpreted and said the law laid down in Garware's case is an erroneous law that could not have happened if at all a document, because it applied the clause of doctrine of severability. It said this arbitration clause is a severability doctrine. It can be severe because arbitration clause does not require any stamp duty or it does not require registration. Arbitration agreement, as he looked into under section 7, it only says it requires writing. If a clause is there in writing, that is sufficient. That is what the law. But what here court did, court said it can be severed from the original document. So if document is insufficiently stamped and invalid, you pass an order under section 11 or under section 9, but you also pass an order stating that the document is impounded and pay duty and penalty within a period of certain time. So this should be the view, and it referred the matter to larger bench. Now the matter is pending consideration before larger bench. So why I'm stating this is how the evolution of law is taking place. Reason that the enactment is very short and there are hardly anything provided in the enactment. Various cases are taking place, and for which reason the courts are interpreting the laws and giving it new dimensions. Of course, the basis for everything is that the courts are keeping in mind that there should be minimal interference of the courts and there should be speedy disposal by virtue of the arbitration. So this was the law under section 9 and section 11, which I've dealt quite extensively with regard to this. Then comes section 16, as I said, and section 17. Section 17 is where interim measures can be given by arbitral award. I'm sorry, before the arbitrator. Arbitrator can give an even interim order, because if you don't get under section 9, whenever an arbitral tribunal is constituted, you can go there, approach the arbitral tribunal and obtain an interim remedy if required. So this is section 17. So if we have to talk about this evolution of law, there is also now this new concept which is coming, emergency award. Emergency award is not described on our enactment, but emergency award concept is being rising in a couple of cases in Delhi High Court. We have found this emergency award, which means that, see, if the court refers the matter to arbitral tribunal, that tribunal may be an arbitration center, where that arbitration center will be appointing arbitrators. Once it is referred to arbitration center, that arbitration center will have powers also to invoke this emergency arbitrator and appoint an emergency arbitrator. This emergency arbitrator will immediately pass an award. This is an interim award for any urgent protection of the matter is concerned. In such situations, the court has interpreted that if an emergency award is passed, then that award might be followed by subsequent arbitrators which has been appointed, or they might also not follow that. That will be for a very interim minimal period. This emergency award will be passed. So this is how the evolution is taking place. This is with reference to section 17. Then comes section 20. Section 20 is regard to place of arbitration, the place or the venue of arbitration. See, there again, place of arbitration, quite few interesting case laws. Under the Act section 20, there is the word only place of arbitration which is referred. The questions before the court have come, what is the difference between place of arbitration, seat of arbitration, and venue of arbitration? Place or seat of arbitration is one and the same. This is required for the reason that if you're filing any appeal after this arbitration award is passed, then which law you have to follow. So this becomes the place and seat of arbitration. Then other thing is the venue of arbitration. Venue of arbitration is irrelevant. For instance, there was one case. In this particular case, the matter was adjudicated in Kuala Lumpur, KL. In Kuala Lumpur, when the matter was being adjudicated, that was considered as seat of venue. Because of some disease called a SARS, which was prevalent in that point of time, the place was shifted to London. Then the question came up before the court, which is the seat of arbitration? Whether the reference to London court was the seat of arbitration or the Kuala Lumpur is the seat of arbitration. Then the court said that since in the arbitration agreement, there is nowhere it is agreed that in a written contract, you should agree for choosing of the seat of venue. Hence, the reference or the shifting of venue will be considered as London court. However, in a subsequent judgment, a different view is taken because that there the matter will be of Gujarat High Court. Gujarat, the Arbitral Tribunal would be Gujarat. In Ahmedabad, the arbitration would have taken place. Subsequently, the venue would be shifted. The venue would be shifted, and the arbitrator would have written that the seat of arbitration is this shifted venue. Then the matter will come up before the court because they will file an appeal. That will be before Gujarat High Court. There it will be dismissed on the ground stating that it was shifted to Rajasthan, so Rajasthan should be invoked. But court said that. No, see, it was mutually agreed between the parties. Though it is written as mutually agreed between the parties, there is nothing in writing which is said. So under the agreement in that particular case, it required that any changes of venue, it should be done in writing. So therefore, court held, since it is not done in writing, even though the venue is shifted, it should be treated as seat of arbitration as Gujarat, and Gujarat High Court has got powers. So these are the few things where the statute won't provide. Because of evolution of laws and the facts of the cases, you can find out such things which have been taken place and been changing. Next, if I have to move on, it will be like the most other important topic will be Section 34. Section 34 of the Arbitration Act. See, under Section 34, the Arbitration Act does not provide for appeal provisions. Once an arbitral award is passed, it will be final and binding on the parties. However, you have been provided this provision of Section 34, where the challenge is minimal. The challenge for arbitral tribunal is very minimal. That is, in the initial stages, it said the arbitration enactment said if it is violating any public policy, then alone the matter can be treated as violation. The arbitral award is violation. So arbitral award violates public policy of India. Then it can be treated as violation. Then that court can interfere under Section 34. The jurisdiction will be the civil courts or the high courts, if it in the case of Bombay or Madras or any other presidency towns. It is again coming under commercial contracts also, those particular jurisdictions will be invoked. So under in the old act, it was like only public policy violation, then alone the courts must interfere. This was again reiterated in various judgments. In 2003, in ONGC Limited versus Saw Pipes case, there also the court brought out this concept of the first time. This is a very important concept. It brought out the concept of patent illegality. If it is patently illegal, then alone there can be interference. Then thereafter, what happens in the year 2000, this was followed subsequently in various judgments. In 2014, there came one more concept of perverse illegality. Perverse illegality, if the order is perversely illegal, then again courts can interfere. And subsequently in 2015, in Associate Builders case, Associate Builders versus Delhi Development Authority, in this particular case, the court held, now what is this public patent illegality and perverse illegality? We'll be bringing out these dimensions. These are the three facets. If the three facets fulfill the conditions, then it can be said as public policy is violated and perversely illegal. So patent illegality and to look into whether the award is patently illegal or perverse, the court laid down three principles. One is the award should violate substantive law. Next is there should not be no reasoning in the award. If there is no reasoning in the award, then again it will be treated as perversely illegal. Then the other one is if the tribunal has wandered around or gone around away from the matter which has been referred to the arbitrator, and if it has not looked into terms of the contract in such a way that even a prudent man, if the contract was given, he would have interpreted in a reasonably fair manner. If it is not in a reasonably fair manner, then the court must interfere. This is what the three possibilities which was laid down in this Associate Builders case. See here, the court said that if the interpretation of a contract, if a person can take two views, both possible views, then even though it is illegal, court won't interfere. Court should not interfere. But if a contract has been interpreted in such a way, even a common man or a normal man would not have done it, only then the interpretation will be, only then the award will be held wrong or bad in law. This judgment of Associate Builders case was again, I can say, judicially interfered by way of 2015 Amendment Act. There, this patent illegality, which was coined in ONGC's case, which I said, 2003, that was brought in the statutory enactment itself. The statute itself brought these words patently illegal. So now the court was supposed to look whether the document is award is patently illegal or not. By virtue of this, the first condition which was there, substantially illegal, if it's substantial law is violated, which was laid down in associate builder's case, it was held as bad law by subsequent judgments, but rest other two is still to be a correct law. Now also the courts are interfering in many matters on this concept that the arbitrator has wandered around, has looked around, has gone beyond the contract which has been provided to him. For instance, very recently, in one case, BCCI versus Kochi Cricketers Private Limited, in this case, no, not this, in BCCI versus Deccan Chargers, Deccan Chronicles, where you will be knowing this IPL cricket team was there of Deccan Chargers in year 2008-9, was subsequently terminated. So when this was subsequently terminated, the matter was referred to arbitrator. Here, a retired Supreme Court judge was appointed an arbitrator. 4,180 odd crores is the damage amount which was awarded by the arbitrator. Recently, Bombay High Court, just few months before, it has set aside this arbitration award which was passed. It has held that this is perversely bad. It has gone beyond the contract which was provided to the arbitrator to decide, and held that it is perversely illegal and patently illegal as provided in the Act. So though this word of patently illegal is coined, it appears to be simple, but still ample powers are there. Of course, if there is wrong application of law or wrong interpretation, that does not make the arbitral award being set aside or bad in law. There is an exception to this section 34. Section 34 is not applicable for foreign awards. And also this patently illegal concept, which I said, it is coming under by virtue of amendment to 34, that is 34(2)(a). That is also not applicable to international commercial arbitration. So with this is only applicable, what you can say, for domestic awards concerned. And thereafter, you've got these foreign awards, which is there. Foreign awards, if I have to say in brief, foreign award is nothing but an award which has been passed outside India is called as foreign. So New York conventions are there and Geneva conventions are the two conventions. Whenever a foreign award is passed in outside the country, it can't be challenged here in this country, stating that even though if the parties are within India, the question came before the court. See, whenever it was interpreting, always the law was that one party should be in India, other party a foreign national. Then if arbitration tribunal takes place outside India, that is called as foreign award. There was in a recent judgment, court has said that even two nationals of Indian nationals, they're going outside and subjecting themselves to an arbitral tribunal over there, that becomes also a foreign award. In such an event, that award can't be challenged here under section 34. That law of the land over there, they have got an opportunity to go and proceed the case over there. And only for implementation, they can come here. That is execution of the award. So with this background, I think my time of 45 to 50 minutes, it's coming to an end. So with this background, my what conclusion I can come here is the basis for the arbitration enactment or this evolution of arbitration enactment is speedy remedy and minimum intervention of the courts. They want the matters to be resolved as early as possible. Especially it is being very popular now in these commercial aspects, commercial agreements, commercial contracts being very popular. However, because the law is still in an evolution stage, a lot of changes are being taken place. Many judgments are being come out, and also it's in the process of coming out. Recently, Section 87 was introduced. That may take some more time, where Section 87 was struck down. It was in 2019 enactment. It was struck down because it violates one of the judgment. So there are these a healthy conflict, I can't say, but still a healthy approach is made by both the government as well as the legislature as well as the judiciary in interpreting this law or to bringing out the speedy remedy. So with this, if there is any question and answers, I think I can take the question and answers. Take the question so that.
Thank you, sir.
Girish?
Girish.
Thank you, sir.
Okay.
Thank you, Anil.
Thank you, sir. Thank you.
Before coming to the questions, the Wednesday speaker 12th day Wednesday speaker is Srimati Saraswati, who is one of the alumnus of Vivekananda College and also the senior civil judge at present Shivamogga. Madam, kindly post the.
Wait, I'm posting. Yes, sir.
Subject is on insight.
An insight into the provisions of the POCSO Act.
Provisions of the POCSO Act in the light of child rights.
It will be there on 14/7/2021 at 7 p.m. We request all of you to log in to this program also. And then I request Girish to move on to asking taking some questions. Yeah.
Sir, Madam Kalpana Madam is having one question. Is not arbitration more costlier than judicial settlement? What do you say, sir?
See, it depends on the matters. It really depends. Sometimes what happens, a matter before the court, it will take years together. So the cost of the litigation, even though might not be higher on that side, but the cost for the delay can't be paid, especially in these commercial arbitrations where you require the matter to be settled either ways soon. See, this is the end of, this is the real reason why the concept of arbitration is invoked. So far as the commercial side is concerned, no, it's not exactly so. You can say that arbitration is always costlier or more costlier, because there are arbitrators where you will be coming for a much lesser price or something like that. Now schedule has been amended, and by virtue of this amendment to the schedule, there is also slabs being fixed. There are many arbitration tribunals also where it's available for lesser slabs. So that is not the basis on which this enactment was constituted.
Okay, thank you. Next question is from Siddharth Muchandi. His question is, the Supreme Court in the matter of IR Swami 2016 has held that issues relating to fraud cannot be referred to arbitration. Will it not narrow down the jurisdiction of arbitration, as many matters will have allegations of fraud?
Sir, no, sir, not exactly so. In IS Swami's case, it is not fraud was not narrowed down. Court did not say that matter can't be referred to fraud. See, in IS Swami's case, what happened was court referred to the earlier judgments. It wanted to, in fact, set aside this Radhakrishna's case, but it did not do so. However, it recognized this two-test formula. In IS Swami's case, this two-test formula was laid down, where the court said that in the event if the arbitration agreement itself, if it is constituted by way of fraud or if it is made by way of fraud, then alone it can't be referred to arbitral tribunal. This was followed in Rashid Raja's case subsequently. In Avitel's case also this was followed. Recently also in Avitel's case, the Supreme Court has elaborately held and it appreciated. It has accepted the law laid down in IS Swami's case and Rashid Raja's case. This two-test formula is called as public flavor test. And it held that it has given much wider connotation. And thereafter in Vidya Drolia's case also, it referred all these cases. It has upheld IS Swami's case and Rashid's case, also Avitel's case. In Vidya Drolia's case, it has said only if the arbitration agreement, if that itself is pleaded to be fraudulently being entered into, if such serious allegation is there, then alone it can't be referred. Otherwise, all matters can be referred. So IS Swami's case, it did not narrow down the principle. Only narrowing down was done in Radhakrishna's case. So presently, by virtue of Vidya Drolia's case, all matters which involves the fraud, it can be referred to arbitral tribunal. Only in cases where the constitution of the agreement itself is questioned by way of fraud, that can't be referred.
Thank you. And next question is from K. Shiv Prasad. What happened when party ignores arbitration agreement and then commences proceeding in courts? Then don't you think it further adds a delay and complications?
Sir, here the question has got two-tier answers. See, one, when a party approaches the court, when parties subject themselves to the court, Subsequently, they can't raise the question of arbitration clause. They can't invoke the arbitration clause. As under section 8, it has clearly stated the first submission. If a party subjects himself to the arbitration, as a given example of partnership deed, in a dissolution of partnership deed, party approaches the court and says, dissolve the partnership firm. Other party in his first statement of objections, then alone he has to state to the court that see section 8 is there. I'm invoking section 8, arbitration clause is there, refer the matter to arbitration proceedings. So therefore, when parties have invoked themselves the civil court jurisdictions, later on at the later stage or even the second stage also, at the second round of submissions also, they can't invoke the provisions of arbitration clause. It is like waiver of the arbitration agreement, and they've chosen the jurisdiction of civil court. The question also came up in the Booz Allen's case, what is this first submission? There the interpretation was in this. He would have filed an application for temporary injunction and appointment of receiver. This other party files objections to it. When he files objections to that applications, the court says, the other side raises an objection. No, after this filing objection, then he files section 8 application. Other side raises an objection saying that, see, he had already filed objections. At that point, he should have raised the issue of invoking section 8. But court says, no. Full-fledged objection should be there on the main merits of the matter. Interim objections can't be treated as first submissions. So this was the law which was laid down in that Booz Allen's case. And therefore, subsequently, you can't invoke the provisions. So that's the next question of delay in proceedings won't come. So therefore, party can't choose like first few years, I will go here, I'll play in civil court or other jurisdictional courts, then I'll invoke the provisions for arbitration. That can't be done.
Thank you. Next question is from Bharati Vallappan. When court can look into arbitration agreement?
See, that's what, as I said, section 8 is the place where court can look into the arbitration agreement. See, I think what you're referring to is probably may not be the reference court. I think court of first instance or where a party would have subjected himself to a civil jurisdiction. I think then this is the question which is arising. Court can look into this agreement only at the time when the opposite party raises an objection. See, for instance, DRT proceedings are there. Surface Act. If there is any violation, then the bank will invoke DRT proceedings by issuing notices under section 13, 13.2, 13.4. This is a special provision. If a party files a suit in civil court, it is settled law that civil court has got no jurisdiction to handle these DRT proceedings. So even if there is no objection from other side, the civil court will dismiss the application or dismiss the suit or reject the plaint stating that it is barred by law. But however, this is not the position in arbitration. Even though if there is arbitration clause under the arbitration agreement, the party, if he invokes civil court jurisdiction, if other party does not raise objection, court can't dismiss or reject the plaint stating that this is barred under law because there is arbitration clause. So it is not, the question can't be like when the court can look into it. Court can only look into it. Court can't suo motu look into it. Court can only look into it when other party objection states that, see, there is an arbitration clause, refer it to arbitrate. Till then, civil court will be having its own jurisdiction, if it has jurisdiction, and the matter will be continued.
Thank you. Next question is from
Girish Kumar, you are not audible. Girish, you are not audible. Girish.
What?
Yeah, if I could take, I think Girish's voice is not audible.
Yeah.
I can take down the question directly. There is
all right, Anil.
one question is from
Anil, 1 minute.
One.
There is a question from Vishnu
introducing
Shivram.
section 87 of the by the Honorable Supreme Court.
Yeah.
Can you hear me, sir?
Yeah, now we can hear you. Just a minute, I repeat the question, Anil. That Vishnu Shivram, he has a question. What is the intention of legislature in introducing section 87 and the reason for it to be struck down by the Honorable Supreme Court? This is his question.
It requires a very elaborate answer for this. See, section 87 is that, as I said, various amendments started, statutory amendments came 2015, 2019, 2021. Then they started questions when these amendments should be taken into consideration, whether it will have prospective effect or retrospective effect. That is, when arbitration proceedings have started prior to 2015, it is continuing, still whether this is applicable, or section 34 application is filed before the court before 2015 and still it's continuing. So when this should be taken into consideration was the questions. Court in various decisions, it had laid down the law stating that whenever after, for instance, section 34 application, this will be applicable only after passing of the enactment is concerned. So if a party files section 34 application after this enactment, then it will come into existence. So this law was settled by the Supreme Court. But however, what this enactment did was, before passing of this law, Law Commission report had given this mismatch which had taken place. Based on the suggestion of the Law Commission report, subsequent to that Law Commission report, Supreme Court had settled the issue. But this legislatures did not see that. Then they passed this enactment of 2015, section 87. This section 87, what it said was, this will come into effect only after all the proceedings which has been filed in the 2015, after 2015. Now this gave into a lot of problems. So court said that we have already settled this issue by virtue of judicial decisions. Now you are invoking this. This will unsettle things. It will again go back to square one. So that's the reason the section 87 was held unconstitutional and it was set aside.
Thank you. The next question is from Hemant Kumar. What can be done if one party ignores the arbitration agreement and commences court proceedings?
See, that answer already I've answered it. That is again section 8 itself. If one party ignores and starts court proceedings, the court proceeding will continue until and unless the other party objects for it by filing section 8 application, saying that, see, there is an arbitration clause. If it doesn't file, then the court proceedings will continue. Arbitration tribunal, there won't be any reference and matter can't be decided before the arbitral tribunal. There is also one question.
Yeah, you can take question, Anil. No problem. You can take directly.
There is one question from my very good friend, Manu. He is also quite expert in arbitration laws. He has posted a question, which I'm not able to find that. Yeah, what is the validity of an agreement containing an arbitration clause authorizing one of the parties to the contract to appoint the sole arbitrator, more particularly its officers for adjudication of disputes, especially in consumer-related products? So this is a very good question. As I said, even he is an expert in these arbitration matters, probably has come across this matter. There is a reported judgment of this. What he's stating, the question is, to simplify it or explain it with an illustration, there will be agreement between two parties. Take, for instance, a contractual agreement between one party and another BWSSP or Electricity Board or BESCOM, where there will be a fiduciary relationship between these higher authorities. They have given a format. You sign this format, this will be the contract. Their arbitration clause will be there stating that, see, I will be appointing one managing director. Our managing director will appoint one arbitrator, and that arbitrator will be the person who will be adjudicating the disputes. Such circumstances, recently the Supreme Court has held that when one person, he himself has got no jurisdiction, because under the schedules, there is schedules are amended, and now by virtue of section 12 and the schedules, a person cannot appoint or ask his subordinate or his nominee to appoint an arbitrator. Because what will happen is, then that person will appoint the arbitrator and best known to him. Earlier, what used to happen was these managing directors would appoint their own civil engineers, their contractual engineers, and they would say that, see, our managing director is appointed, that's the contract. So this law has been struck down by the Supreme Court, stating that this can't be the practice. When a person himself has no power to appoint arbitrators, this is like he himself being appointing one arbitrator and other parties should bind by it. So the court says that sole person can't appoint the arbitrator. This is the context.
Thank you. Girish?
Thank you very much. Thank you very much. Still many questions are there, but time is not there. Thank you. Thank you for having a wonderful session by Anil. I congratulate you.
Thank you, sir.
And I also thank the participants who are present today. And I also thank the principal of Vivekananda College and also the participant Advocate Association President AP Rangnath and Treasurer Shivmurthy, and also I thank everybody who participated today's session. Thank you very much.
Thank you. Thank you, Anil, for your lucid presentation on the subject that clearly indicates that how authoritative are you in this particular field. And then when you take up question of your best friend, Mr. Manu, still I remember one incident when we felicitated you as an outstanding student. Manu had an objection. He came to me and then he told me, sir, you should have awarded me with outstanding student because Anil was always inside the college. You awarded him outstanding student. I was always outside the college. You should have awarded me out an outstanding student award. Still I remember. Manu, thank you very much for joining us. And then I profusely thank Anil and all the participants here. And I especially mention and acknowledge the presence of Shri A.P. Rangnath and Shri Shivmurthy sir from Bangalore Bar Association and all legal practitioners, those who are present here, and all academics, those who are supporting us. And especially I mention students from Crescent College, Chennai. They, from day one, they are attending our seminar. And my special thanks to those students and also the students from other institutions. And I expect the same cooperation from you for our future endeavors. With this,